number 105, Centi versus McGillin. Good afternoon, Counsel.
Good afternoon. If it pleases the court, I'm Edward Flink, and I would like to reserve 2 minutes for rebuttal, please.
Yes, sir.
Counsel, what's the, as succinctly as possible, could you articulate, what is the public policy reason we would overturn this agreement?
To not allow a criminal who has garnered illegal money to use the courts to collect that money.
So let's say it was 50% gambling proceeds and 50% lawful earnings. What would we do?
I think that would be a closer question, but if, in this case, it's 100%, and it was admitted to be 100% gambling proceeds.
What's our rule going to be? Does it have to be 100%? Does it have to be at least 80%? Because it seems to me, one, as you know, and we've recently reiterated, it has to be a very strong public policy articulation in order for us to override an agreement between consenting parties, right? So I could see a case where the transaction itself was designed to disguise the proceeds of illegal activity. I'm going to pay you this money and we'll arrange it so it looks like it's coming from X when it's really coming from gambling, and then you'll pay me back, right? And then I'll wash the money. But that's not what you're saying here. You're saying, as I understand it, the fact that, and let's assume 100% of the proceeds here were the proceeds of gambling activity, that whatever arrangement I enter into, it could be with, you know, a local bank, but because it's the proceeds of this gambling activity, that for public policy reasons is going to void whatever agreement I've entered into.
It's going to deprive me, this case, the lender, from the opportunity to come to the courts to collect the debt. Yes.
Don't you have a problem because findings were made that in fact this was a loan and not some, you know, I'm going to let you hold my money and you can give it back to me a little bit at a time? Doesn't that affect your argument?
I don't think so, Judge, and I think this court in McConnell versus Commonwealth Pictures, where the very same issue was presented, there the money that the plaintiff sued was the fruit of an admitted crime, and the court held following.
Well, in McConnell, the contract itself led to illegal conduct. Here, there was illegal conduct on the part of both parties, I might add, and then there was this contract, which now there have been findings was to make a loan to somebody. So how is the contract itself? I'm going to loan you money to build a house, and you're going to repay me. How does that in itself involve illegal conduct?
I thought actually in McConnell the underlying contract was not illegal in and of itself. I may have misread that decision, but
Well, but it was executed through illegal activity. That's what I'm saying, that they had a contract and then one person went out and in order to fulfill the contract did something illegal.
Okay.
So that's a little different from what we have here, I think.
Well, in the Kirshner case, the court also talked about the idea that you have two wrongdoers in pari delicto. They're not going to allow the plaintiff to come in and use the courts. And this is criminal conduct. That would seem maybe to be if the two of them had been in business together, Centi and McGillin, in a bookmaking business together, and they had an internal dispute about who was entitled to what share of the profits, and they came into court and said,
you know, we had a oral agreement as to how, you know, who owned what share of the business, and it's gambling business, will you enforce it? We might then say, no, we're not going to do that, but this is different from that, no?
Well, I think because as a matter of law, in legal interpretation, Judge Egan, joined in by Judge Lynch, felt that because the proceeds were garnered illegally, that this was in fact money laundering.
How is it money laundering? How does this meet the elements of money laundering? Because I'm not following that.
Well, under 470.05, money laundering in the fourth degree, a person is guilty of money laundering in the fourth degree, any felony, when knowing that the property involved in one or more financial transactions represents the proceeds of criminal conduct. I think we meet that. He or she conducts one or more financial transactions which in fact involve the proceeds of specified criminal conduct. I think we meet that. Knowing that the transaction or transactions in whole or in part are designed to, capital A, conceal or disguise the nature, location, the source of the proceeds of the
So
criminal.
there's an intent.
There's the problem, I'm sorry. Isn't that last thing that you just read? Where's the concealment? Where's the, they both know
No,
what the
it's-
source
it's-
is. They
it's
both
cons-
know because they're in it together.
Well, you mean conceal
So
from...
from the public, the authorities.
How is this designed to do that? Usually that's where the money is going through something so that the source of it is disguised. Here he's taking it out of whatever, an apartment or somebody's house in a suitcase or whatever, and giving them to somebody. It's a loan on its face. There's no attempt to disguise where that money came from. So if there had been an agreement on paper with the other party saying, you know, this money that you've gotten from X, which wasn't true, or I'm going to do this through a foreign bank account, but this is just, I'm taking the money out of my house and I'm giving it to you. I think it was in cash, right? So how is that transaction disguising where that money came from?
Well, it's not just that transaction. It's then the payback of those proceeds in $1,600 increments every 4 weeks, which then Centi uses for his spending money or walking around money, and
Why couldn't he
therefore...
have just taken it out of the safe and spent it on his spending money or walking around money? How would that be any different?
Well, I guess he wouldn't have then been in this situation, and he would have had the money all along.
Why wouldn't that be money laundering, though? Suppose he bought a bunch of stuff on a credit card and used the money in his safe to pay the credit card
Well,
bill.
that
There's a
would-
contract with the credit card company to repay it. Why isn't that money laundering
Oh,
also?
I think that would be money laundering, yes.
So your rule really is that if you've got illegally obtained money, you can't spend it.
No, if you have illegally gained money and you then commit money laundering,
Spend it.
you
You
can't
spend
go
it.
into the court and ask to have the court help you collect it back.
Of course, there's limits on how much you can spend it, right? If you walk in a bank with $15,000 in cash, they're going to want to know where that money came from, right? Once it goes over $10,000. So these are, I don't know if they're realistic solutions to the disbursement of money. The interesting thing is, when you look at, I've only done some preliminary research on this, but when you look at contracts that violate public policy, it seems to be there's 18 different categories that I've identified so far in research on it. And it always seems to involve a basic breach of the public good, but also a breach and that tends to an action that tends to promote the breach of the law. So the question for us would be, I think Judge Feynman made a good point on concealment. I don't know if this exactly fits into the money laundering statute. I think that's a legitimate point. The question is, does it involve a situation where we would be establishing a rule where illegally obtained funds could be spent in Montgomery County if they're spent on specific types of economic transactions? So someone from anywhere in the world could come in and bring their drug money in and spend it in Montgomery County. In the state of New York, as long as they said, I got this money from an illegal drug transaction, and they were upfront about it. It seems to me that that's the problem here. Isn't that the public policy that we're concerned about? Not, because otherwise, I think you're required to come to us and say, these sections of the penal law are being violated, because that's one of the clear 18 categories so far, and you haven't done that for us, have you?
Meaning I haven't,
You haven't told us any other category besides money laundering that violates public policy under the penal law.
I'm just handling this one case. And
Well, judging by the name, I figured that. In fairness to you, I thought that.
And I appreciate the question, Judge, and I think you're not, I don't think I'm disagreeing with the basic premise
go ahead.
here. And I guess what I'm saying is that when you have, I'm dealing with this case. Obviously, we all are. I'm not disputing that the determination was made that this was a loan. I'm past that.
So there's no statute of frauds argument?
No, correct. And it's not
Okay.
reviewable by this court anyhow, and that was, we're past that.
All right.
And I'm not going to spend the time talking about whether or not there was sufficient proof as opposed to the weight of the evidence. I'm glad that we're at least talking about the fact it seems like this court feels that it has jurisdiction to decide this issue, because I think as a threshold proposition, we have to decide that this is a legal question as opposed to a question of fact. So the characterization by Judge Egan as money laundering, I wish I had come up with that in the appellate division or the trial judge in the trial court. I didn't try the case, but at the end of the day, this isn't the first time that a judge has declared a rule of law in
Of course, we also
declaring the
have the
whole law.
problem that it's an unpreserved issue, but
But I think, but that's where you get into that whole law issue that this court spoke of in Persky here, that it's, as I think Judge, and that was a negotiable instrument case where, in our review, we are confined to questions raised or argued at trial, but not to the arguments there presented, nor is it material whether the case was well presented to the court below in the arguments addressed to it. It is the duty of the judges to ascertain and declare the whole law upon the undisputed facts spread before them, and it is our duty now to give such judgment as they ought to have given. And that's what Judge Egan wanted to do when he connected the dots and said...
I understood that, but my question, if it's all right, Judge, because I see your lights on. It's okay. My concern was, is there another category that you would point us to besides money laundering as a violation of public policy, besides the one that Judge Egan pointed out? Because public policy invokes the broad equitable powers of this court, but they're rarely invoked. We're talking usually about contracts. Let's say you made a contract to kill someone, or you made a contract to commit treason. Those are the kind of circumstances where the court has invoked the public policy argument based on its own equitable power. And clearly this isn't that kind of case. So that's why I'm asking you, point to me where in the penal law or the broad equitable principle that will be underlined. Otherwise, I'll continue my research.
And I can't do anything more than say what I did, and again, get back to the idea here that the intent to launder the money, I believe, was inherent in the act itself. He's putting back into the economy these small amounts of money, and he's doing this with the assistance of his friend and gaining interest as well, and now asking the courts to help him get his money back.
But your view would be no different if he'd loaned the money to me, right?
That's correct.
Okay.
That's
Thank you,
correct.
Mr.
In this case, there was a in pari delicto, but I would agree with that, Judge.
Thank you, counsel. Counsel?
Good afternoon. May it please the court, my name is Dan Centi. My client has the same spelled last name, but he pronounces his name differently, so we distinguish ourselves that way. McConnell cited by the dissent, and I know they don't state it as stating the proposition of money laundering here or the principle they're applying, but it is a totally different type of case. It's a commercial.
But isn't it really a perversion of the legal system? You're suing to get back illegally gained funds that you have hidden from the government. And the court is going to order not only the repayment, but as counsel just pointed out, interest on top of it. So he's doing better than just hiding it under his own mattress.
I hope you don't view it as a perversion, Your Honor, because if you look at McConnell, what McConnell held, by the way, the case was totally different. It was not only a bribery case, The defendant pled facts showing illegality. The plaintiff had not been subject to any statutory sanctions. I'm kind of listing the factors that this court uses in evaluating these cases. And as Judge Stein pointed out, there was no misconduct occurring in our case, as opposed to McConnell, in allegedly procuring the contract sued on. And if you read McConnell's holding that this court
So you would say that it needs to be in the formation of the contract itself, not in the assets that are part of the contract, unless there was an attempt to conceal them some way, and then you get into statutory penal law problems.
Yes, I'm saying that if you look at Lang Capital,
Okay.
Lloyd Capital that we cited, and this court decided, and that's a fairly recent case, 92. Basically, this court has said, you can't come in and ask us to command illegal conduct. In other words, enforce the very conduct that is prohibited. And I think Judge Wilson was asking about that. You can't come in and try to enforce a legal contract where let's say in a gambling case,
Counsel, would it be different if here, going back to something Judge Rivera was saying, so the government has certain mechanisms for going after this type of proceeds, right?
Yes.
There's fines in a criminal case, there's asset forfeiture, right? Would it be different if the transaction was designed to evade those efforts?
Well, that's what the dissent seems to be suggesting.
But is there
right?
any proof in the record of that in this case?
Oh, no, not at all. Not at all. As a matter of fact, I'm really annoyed, pardon me, for the
No,
fact...
the question.
Not by your question, by the holding, the dissent saying it was money laundering. The first time that was even argued in this case is before you.
But it seems to me that this
there is
whole
no money
argument
laundering.
about the transaction here, if it's not designed to evade fines or evade asset forfeiture, you come into court and you're enforcing a contract like this where it's sort of coming out that these are the proceeds, or at least the allegations are coming out that these are the proceeds of illegal activity. Right. Certainly the government has tools at its disposal to enforce whatever rights it has against the proceeds of illegal activity as a separate mechanism here, right? If there was still...
No question.
Right. So I think that goes back again to Judge Fahey's point, the distinction, and I think you were making, between a transaction that is requiring the courts in some way to enforce something that's against public policy versus a transaction that involves in some way the proceeds of prior illegal activity.
Right.
Does it also matter what the nature of that prior illegal activity was? We have these concepts of malum in se and malum prohibitum.
Right,
and,
right.
I guess, does it matter where this falls in that? Because I think everyone would have to agree that it's a little, to use a colloquial term, yucky for courts to be wading into these types of disputes no matter what. But the question is it so much against public policy that it outweighs the public policy in favor of the right to contract? So does that make a difference, and
No,
if so, how?
Proceeds of a kidnapping.
Yeah.
No question. I mean, I think even in McConnell, this court spoke of gravely immoral and illegal conduct. Not just immoral, gravely immoral. And they don't quote the holding, the defendant here, but they start talking about malum in se and malum prohibitum. They say malum prohibitum means you just can't enforce the thing. It's too grave or something. But malum prohibitum means it's simply prohibited because it's illegal. And it's not immoral. And we all know, no one in this room, I think, would say that gambling is immoral conduct. We can go down into downtown Schenectady and not just do football bets, which is what they did here, but bet on any sports I've never even heard of before. And public officials attended their grand opening. I mean, I think we're past saying it's immoral conduct. It's prohibited. They inexcusably violated that prohibition. But it's not immoral conduct. And certainly if this was a bank robbery situation and they got back to their lair and divided up the proceeds and he gave a loan to them of the stolen proceeds, I don't know what would happen in that case, but it sounds like a significantly different case than what we have here.
How is it significantly different?
Because we don't have any gravely immoral conduct. in obtaining the proceeds or in deriving the proceeds. What we have is illegal conduct. And this court said as far back in 1921 that in enunciating public policy, the court is reluctant to do that. This is a Messersmith case, that your field is narrow when there are sanctions.
But you are limiting the conduct to the bookmaking on its own, as opposed to the hiding the proceeds from the government, lying about the proceeds that you have.
There's nothing in the record that my client lied about proceeds.
Well, he didn't pay taxes on them, I'm assuming.
I've
never met a bookmaker who pays taxes.
The record shows he pled the fifth and was asked about taxes.
Okay.
But under the case law, that is not considered. It has no probative value as to whether the contract should be enforced.
You understand my point. It's
Yes,
self-evident, which is that, all right, you're taking the money, you're not paying taxes on it, there are illegal gains that you haven't paid taxes on, and then you give it to your friend who builds a house, and he pays you back over 11 years. And over that 11 years, then all that money that's paid back is legal. And it wasn't legal before, and you hid it because you didn't pay any taxes on it. So this is not the work of an upstanding citizen. It may not be a mass murderer, but on the other hand, it isn't one of nature's finest either.
I think the court has dealt with those issues before, though.
That's the question, then, really.
Yeah.
How bad is it, right? The question really for us is, as a matter of public policy, does it fall within those categories that would affect broader societal goals, which are always difficult to earmark. But it's an interesting question.
But in answer to your question, Your Honor, in that capital case that I just mentioned, this court said that if we're not commanding illegal conduct, then the overriding general policy is that we will not allow the defendant
So
to
that's
get
why it
something
goes
for
to the
nothing.
formation of the contract itself. That will be your argument.
Right. And you know, that was relied on by the trial court, too. The overriding general policy applied. There are competing policies in a lot of cases, but that's the overriding one.
What about commanding the interest? Not just pay back the exact amount owed on the loan, but the interest.
I think that would come under that overriding general policy of getting something for nothing if he doesn't pay, which wasn't an exorbitant interest rate at all, 3.9.
No. It's you're using stolen money.
No.
That you're not, excuse me.
Okay.
Okay. You're using gambling money.
Right.
Okay, but illegally gained profits, we can agree to that phrase?
Well, they both testified
We can
there
agree
was
to
no
that
profit.
phrase. Illegally
Profits.
gained profits that he's then using to gain more money from those profits that he's not reporting to government, he's hiding from the government. How is it in furtherance of public policy to involve the court in signing off a judgment and order that requires that he pay? I assume if he doesn't pay, he's going to be in contempt. And I assume there may be even more legal action against him if he doesn't pay. At any point now, are we perhaps in the sphere where this becomes just, perhaps as where Judge Fahey was going, a bridge too far, and now it really does become a violation of public policy?
Well, I think those are the rules that we've been living by and that we've been guided by. The trial court was guided by. The appellate division majority was guided by.
If he doesn't pay, can the plaintiff use legal process to take away his house? To enforce the judgment?
I think there's a strong public policy in encouraging people to use the legal system and not use extra legal means to obtain
Garnish
debts.
wages if he was working?
Yes.
To access his bank account?
Yes, Your Honor.
Okay.
Thank you, counsel.
All right, thank you.
Counsel?
Just by way of quickly, there was no waiver. The illegality defense was all over the case. Judge Seiss decided there was no waiver. I don't know where you're going to draw the line on public policy and at what point the courts are going to wade into this. But I do agree that there is something, to use the legal term, yucky, about this court and the courts in general not stepping into this and not just leaving them where they lie. The reality is this conclusion of law that it was money laundering. I submit if you look at 470-05, it is money laundering. And where you are laundering money and using
If we
these-
disagree, do you lose?
Excuse
If
me?
we think it's not money laundering, do you lose?
I think it's a closer question, Judge. I have to admit that. I have to admit that. But I do still believe that the same rule about announced by this court in the Stone case, as well as thereafter in McConnell, about leaving the parties where they lie and not using the courts to allow somebody to regain the illegally garnered proceeds is a public policy in and of itself. But I do acknowledge that if it's not money laundering, it's a different issue. And I can't...
If we just see it as he's got money made off the gambling,
I still
and he
think
loaned
that,
it,
I still think that
and he
public...
wants to be repaid, then you're saying you lose?
I don't say I lose, but I think that it's a closer question.
Thank you,
I would
Counsel.
have to acknowledge it. I don't know that just because but I do believe it's money laundering, but I do agree that it's a closer question, and it's a public policy issue that's not as clear.
Thank you, Counsel.